Good evening, everyone. Welcome to the Williamson County School Board meeting for May 16th. Board members, since I traditionally forget this, I'd ask you to please record your attendance now so I don't forget it. Great. Thank you very much. Thank you, Board. Next item under new business is E, proposed settlement of pending lawsuit. Dr. Looney.
Mr. Chairman, I do recommend approval.
Okay. Anyone like to make a motion for approval? Mr. Hull, would you like to make a motion for approval? We have a motion, a second. Second from Ms. McGraw. And Mr. Hullett.
Thank you, Mr. Chair. I'd also like to make an amendment to this motion that we reconsider the settlement, with the only thing changed to the settlement offer being the amount, and changing that amount to $35,000, please. Oh, $36,500. My apologies, $36,500.
$36,500 on the settlement. All right, that's a motion for an amendment to it. Anyone like to second that? Second from Mr. Wimberly. Okay. Comments or discussion on the amendment? Mr. Mazzara.
Thank you, Mr. Chairman. I'd actually like to speak to the motion at hand, not the amendment.
Jason.
Well, procedurally,
I know.
you just want to wait until...
I requested to speak prior to the amendment being offered.
Okay. So he'll remain in the queue until after a vote on the amendment.
Okay. The attorney has said to wait until after the...
I know that.
Okay.
Thank you.
Thank you. Any other discussion specifically about the amendment? Okay, I see none. Then we make a, if you go ahead then and record your votes on the amendment to the motion, to the resolution, I'm sorry.
Your vote is 11 yes, 1 no.
Okay, so we have on the floor then an amended resolution.
And Mr. Chair, if I may, just to make sure that the board is clear on this, the proposal was actually a higher number than that, so this actually constitutes a counter offer to what was brought to the board originally.
Okay, Mr. Mesra.
Thank you, Mr. Chairman. I could speak to the parliamentary procedure of how this came about, this motion. I believe that it should have been brought forward for reconsideration by one of the voters in the prevailing majority, but there was none, so I'm not sure how that works. But nonetheless, when I last voted on this matter, I had stated that I was voting no based on principle. I think it's funny how life presents us opportunities to test our words and convictions. I would imagine that if I were to change my vote for an additional savings of $13,500, then I really didn't vote based on principle. Principles should not be swayed by money, whether a little or a lot. So I'll be voting no again, based on principle. Thank you, Mr. Chairman.
Thank you. Ms. Curlee.
Thank you, Mr. Chairman. We're usually kept in the dark regarding lawsuits brought against the district. As a board, we have not historically been briefed on the details of legal matters, much less threatened litigation against the district. As a board, we have historically not voted on settlements. Although there have been suits brought against the board, it seems there has been an intentional effort to make public only those that can be twisted for political purposes. Although we have a policy and code of ethics prohibiting political activity, the board has knowingly turned a blind eye to rampant political activity that has been divisive, disruptive, and ultimately cost the taxpayers and children of this community. Now there are two well-documented instances where the actions, events, and circumstances leading to litigation have been willfully and intentionally misrepresented not only to the board, but to the public. This has been one of those cases. Information was knowingly and willfully misrepresented to the board after the district was contacted by a news agency. As a Brentwood homepage stated, after it became apparent that news of a student fight was going to become public, our superintendent of schools sent an email to board members. There was knowledge this event was going to be televised, and it would possibly look negative on the way the administration and the district handled a particular incident. It's my opinion that a scapegoat was sought. In my opinion, the initial email to the board was not in good faith, as there was information that was intentionally and willfully excluded. My comments were projected in a false and misleading light, and how they may or may not have contributed to a parent going to media. In my opinion, negotiations and mediation have not been conducted in good faith, as there has been an intentional effort to assign blame and assess monetary damages without proper adjudication. One person cannot play accuser, judge, jury, and executioner without violating someone's civil rights and liberties. In an affidavit, a parent recounted a meeting that took place on February the 24th. And the parent stated, "Despite my repeated correction of the actual facts to Dr. Looney, he persisted in his statements and position that Mrs. Curlee had violated the law by her comments in my Facebook post, and I had violated the law by releasing the video footage to the media, and that by Ms. Curlee's actions and my own, that litigation would ensue." Were similar comments made to the claimants, and thereby encouraging potential litigation and a settlement that is before us tonight. To date, legal representation that I have obtained to represent my interest has been ignored, dismissed, undermined, and excluded. Perhaps that is because I am not technically a party to this because a lawsuit has not been filed. Or perhaps it is because what could have been brought forth did not fit a politically charged narrative. Again, one person cannot play accuser, judge, jury, and executioner. Strongly believe that this matter is not coming before us tonight to mitigate cost to this district, but for political purposes and to be used for political fodder in an election year. To date, no legal action has been filed. No jury or judge has decided guilt or innocence. No legal body with statutory authority has determined if damages have in fact occurred or should be assessed or awarded. Setting a precedent for settling threatened lawsuits may encourage others to do the same and expect a settlement in return. Most dangerous and reckless is allowing someone to assign guilt or innocence and use the court of public opinion. By making this a public spectacle, that precedent is being set. We should all expect that anyone who dares to question or raise concerns to fall under the same circumstances and be subjected to the same kangaroo-style court antics. If tonight's agreement is to settle without casting blame and to truly hold no one harmless, then no individual should be mentioned by name, as mentioning someone by name only proves the political nature in which all of this has transpired. If there is no blame to be cast, then I move to amend the settlement by striking the second and third sentences from the opening paragraph in the settlement agreement.
Okay, you then are offering to remove, I think you said the second and third sentences, is that correct?
Yes,
Okay, so that's your motion?
that's my motion.
Okay, a motion for an amendment to remove the second and third sentences. Anyone like to second that? Ms. Emerson, second the motion. Any comments, discussions? Mr. Gregory?
I don't have this thing memorized, so I don't have any idea what those sentences say.
The county attorney is present. If the board wishes to look at that proposal, then my recommendation would be that you recess for that purpose, if that is something that the board as a whole desires. That document, per the state's Open Records Council, is still privileged because it's attorney work product that the county attorney was involved in creating. So it's not a public record at this point.
Okay, Mr. Gregory, are you wanting us to have time for you to read through the second and third sentence?
I can either abstain or we can recess. I'm perfectly comfortable abstaining on it.
Board members, would you like to recess to read through it to refresh your memories of this or not? Mr. Mesra?
Mr. Chairman, thank you. I think that if any of the board members feels uncomfortable with the information that's being presented and that they're not adequately informed, then I think it's incumbent upon us to recess for that individual so that they can make an informed decision.
So if I may, procedurally, the motion to recess would take a motion, a second, and it's not debatable.
Okay, there's some people who have chimed in. Should we call on them to speak before we take a
There's a motion
and a
to
second?
Well,
recess.
at the moment, Mr. Mesra has the floor, so that if because the nature of a motion to recess is a motion and a second, if before he yields the floor, he makes a motion, then the others may not have that opportunity prior to that particular vote.
Mr. Mesra, are you wanting to make a motion then?
Thank you, Mr. Chairman. I'd like to make a motion to recess for 2 minutes.
Okay. Speed reader? You
Better
speed
read
reader,
fast.
Mark? All right, anyone like to second that?
It's been seconded.
I'm sorry, Doctor, I didn't hear you. Okay, then as Mr. Golden said, it's not debatable. If we'd go ahead and, can you set up a vote, or we need to do this by voice, or?
There has to, but it requires a motion, a second, and a vote, a
Okay,
non-debatable
do
vote.
Voice.
We go around and call the roll on this one, take a roll call vote.
Kenneth Peterson. No. Dan Cash.
Yes.
P.J. Mazzara.
Yes?
Ann McGraw. Yes. Gary Anderson.
Yes.
Jay Galbraith.
Yes.
Robert Hullett.
No.
Candy Emerson. Yes. Rick Wimberly.
Yes.
Beth Burgos. Yes. Mark Gregory.
Yes.
Susan Curlee. Yes.
Okay, take a recess.
And Mr. Mesra said 2 minutes, so what I suggest to you as board members is go out that back door, take a right into the larger room, and move quickly.
I don't need to go.
Everybody back? All right, we'll go back into the meeting, and we're still on the discussion about the amendment to remove the second and third sentence out of the document. Mr. Peterson, you were next.
Don't worry about
You're
it.
fine? Okay. Anyone else like to comment on this? All right, Mr. Golden, and we are voting on this amendment to remove the second and third sentence. And that's the only thing we're voting on right now, is that correct?
That's correct. And Mr. Mesra and I had a short discussion during the recess, and he had asked a question while the board was in session regarding the question of a motion to reconsider. There were actually, as you all may recall, two separate proposals that were brought to you. The first one was voted on a month or so ago. The second proposal is what's on the agenda, and that has different language from the first proposal.
Okay. Any follow-up after Mr. Golden's comments? Okay, I see none. Then if we'd go ahead and record our votes at this time for just removing the second and third sentence out of the document.
Your vote is 3 yes, 9 no.
Okay, so then we are then back on the amended motion, which the change is the proposed settlement as amended to $36,500. That is where we are right now. Any further discussion on that? Okay, I see none. If we'd go ahead and record our votes.
Your vote is 10 yes, 2 no.
Okay, we have passed the amended proposed settlement pending lawsuit. You wanted to make a comment?
Yes, sir. I feel obligated to make a comment tonight after the comments that were made tonight, and so I feel like I have an obligation to protect my good name and character. The reality of it is we have been placed in an unfortunate position as it relates to a legal matter, and right is right and wrong is wrong, and I will tell you that I hope that this board is getting to a place where we can focus on the business at hand rather than throwing rocks at one another and encouraging people to go to the media outside of board policy. Whether that particular parent intended to go or not, it's really not the point. The point is, Mrs. Curlee, you advised somebody to go to the public outside of the process that we have established and agreed upon. And the email that has become at debate was only sent to board members. It could have very easily been solved had you attested to the fact that you didn't send that email. And so, you know, the truth of it is I honestly believe I've acted in good faith, and I'm sorry that we're here and have costed the taxpayers money.
Okay. Ms. Curlee, you wanted to follow up on that?
Yes, sir. I think it's interesting that you would take that stance, Dr. Looney, when you knew full well that the parent had in fact followed the chain of command. The parent had notified you. She has a sworn affidavit that says she had met with you 4 days prior and that you had full knowledge of her expectations to go to the media. The way that email was portrayed to the board, it omitted the whole gravity of that parent's post, what she had conveyed, the numerous others who had commented on it. If people are to stop throwing rocks, Dr. Looney, I believe that also starts with you. You have made me a target. I have asked you repeatedly to stop. My expectation is that you too will follow the superintendent's code of ethics that has been authorized and it's recommended by TSBA. In my understanding, it was also developed by TOS. I've tried repeatedly to get it on this agenda. And that request has been repeatedly denied. I would hope that you would treat board members equally and you would refrain from interfering in elections. If the politically charged nature of this board is to stop, it begins and ends with you.
Okay. I believe that's all we have. Meeting is adjourned.